Hey everybody, thank you for tuning in. You've reached The Real Estate Fix. I'm your host, Rich Szerman on KHTS 98.1 FM, AM 1220, your hometown station. Thank you guys for tuning in this morning. It's going to be a lot of fun. I have a special guest in today, special guest in my life every day, luckily for me. My wife, Jane Szerman. Those of you who've heard her before, watched the show, know she is a real estate attorney, quite an accomplished one. And yeah, you don't need to send me emails asking why she's married to me. It happened, live with it, it's good. I married above my station, just leave it at that. But I want to go over a couple of things before we get into, so we're going to ask her some questions today. We're going to go over sort of foreclosure defense. We have an attorney to talk to who is very well versed in these sort of things. So we're going to pick Jane's brain a little bit, see what she can teach us about. Before we do that, I want to give you guys some market stuff real quick. First thing to know is that mortgage rates are down for the second straight week. This is a very, very big deal and hopefully becomes a helpful one. Mortgage rates, a 30-year fixed mortgage rate averaged 6.19% as of December 4th. That's down from 6.23% in the prior week and down from 6.69% the same period a year ago. So we've lost about a half a point. We've gone down about a half a point since this time last year, which is good. It's not enough, but it's good. And just so you guys know what that means, I mean, you hear 6.19 versus 6.23. It doesn't sound like a huge difference or anything. But just so we go over these real quick, at $800,000, so let's say you buy a $900,000 house, you put $100,000 down, and you get an $800,000 loan. So you got $800K. So at $800,000 at 6.69, that was a year ago, your payment would have been $5,156.92. And that's not counting taxes and insurance. That's strictly payment and interest. So $5,156. At 6.23%, which is what the rate was last week, that same payment is now down to $4,915. At 6.19, which is what it is now, that payment comes down to $4,894. So not a huge difference, but there's a huge difference between $4,894, let's say $4,900, than to $52 that it previously was. So you're saving about $6, $7, $8 a year, something like that. So that's not a bad thing. That's definitely a step in the right direction, but not enough. In order to reach normalcy, and I've been saying this now for the past 2 years, we've got to get the interest rate under 6%. When the interest rate gets down to about 5.5%, that's when normalcy will be restored to the market. Until then, it's just going to be the wild, wild west. So 15-year fixed rate mortgage also came down. Came down to 5.44%, down from 5.51 the week earlier, and down from 5.96 a year ago. And the math is pretty much the same. You're saving several $1,000s a year, a couple $100 a month, several $1,000s a year with the lower interest rate. Now, once it gets down a little further, then we'll have something to really talk about. But we're not quite there yet. But the central bank is meeting. This is important. The Fed is meeting next week to determine whether it will leave short-term interest rates unchanged or if it's going to lower them. I had said last time around I didn't think they were going to lower them, but we got a really bad jobs report, which is bad for the economy, but very good for interest rates. We got a pretty bad jobs report earlier this week, so I think now the Fed is going to lower it. I don't know if the market's going to react to that. I don't know if the market's going to lower the rate, but I think the Fed's going to lower it at the next meeting. It'll be the last one of the year, and they're going to lower it a little bit. So we will see what happens. So, and keep in mind, the Fed doesn't set mortgage rates. They have a huge effect on mortgage rates, but it's not like the Fed driving. Sometimes the market gets there ahead of the Fed. The Fed had nothing to do with the market coming down this week. So we'll see what happens. I think a lot of the prognosticators out there have already priced in the Fed drop that's coming. So we're just kind of there. So expect a little bit lower interest rate going into 2026, which is good. But you can also expect lower prices on houses. So which brings me to my next topic. When home sellers set prices too high, they're paying for it. This is something I have been preaching for the last year and a half, 2 years. I've been telling you, if you got a house to sell, get into the market as quickly as you can because the market is coming down, and it better be a deal. If your neighbor sold his house for $900,000 6 months ago, you are not getting $900,000 for yours if it's the same kind of property. If it's a nicer property, maybe you're getting about 7.5% less. Now, again, those of you who listen to the show, I was saying we're going to lose between 3 to 5% at the beginning of this year, by the end of this year. I said by the end of 2025, we're going to lose between 3 to 5%. We've actually lost 7.5%. The average home in the Santa Cruz Valley has dropped 7.5% in the last 12 months. Now, there are a lot of reasons for that, one of which is what's going on at the White House, because, again, whether you like him or hate him, the current occupant, President Trump, is a chaos agent. And that might be fun for you, and it might be fun to watch, but it is very, very bad for markets. Markets crave stability. They need to know what the world is going to look like next week, next day, next week, next month, next year. You can't do that with the current occupant of the White House because he changes his name like the wind blows, it would appear. And he does silly things like tariffs and stuff like that, which are just bad across the board. But anyway, so yeah, sellers set prices too high because they've not adjusted to the new market. And what we're discovering is that on average, these are average numbers in the United States. If you have your house on the market 60 to 75 days, you have to drop it at least 4.1% to get it to sell. If you've been on the market for 90 to 100 days and it still hasn't sold, the average drop is 6.585 to get it sold. 120 to 150 days, 6.75. And if you've had your house on the market over 180 days, it's 8.25. If it's over 210 days, it's actually 10.1. That's just the average where you got to drop the price. What you really need to do is look at the value of the property. If your neighbor's house sold for $900,000, 7% off of that, put your house on the market. You're probably looking at about $870, $880. That's just the reality of it. And sellers who embrace that reality profit from it. Sellers who don't. So if you have a townhouse to sell or something like that, and 6 months ago it was worth $600,000, but now it's worth $550, you need to embrace the fact it's worth $550. You need to list the house at $550. You need to get it sold. Because the only thing that's going to happen in the interim is you're going to lose money, you're going to waste time and energy. That's about it. So if you have a house to sell, it better be a deal. And if it's not the greatest deal financially, maybe it's the greatest deal because yours is the only one that has a kitchen or a view or whatever. But it has to be a deal. And if it's not a deal, it's not going to sell. It is just that simple. So that's kind of the market wrap. The interest rate's gone down a little bit. The prices are still coming down. It's not an avalanche. They're not dropping like they were in 2008 and 9. It's not going to be that. But prices are coming down, and they're still going to come down a little bit. I think we still got another 3 or 4% they're going to come down before they start to stabilize. But a lot of that is controlled by what happens with the interest rate. The interest rate gets under 6%, prices stabilize. The interest rate stays over 6%, prices continue to slide. That's just where we're at. That's the shorthand for you. So last article I want to talk to you guys about, talked about it a little bit last time as well. Foreclosures are surging. They're surging under Donald Trump. I don't think he's the only reason for this. I think the market has a lot to do with it. It was already sort of set for this. But the number of foreclosures is for sure going up. Foreclosures are up roughly 20% nationwide, the number of filings that is. Now, the difference between a foreclosure filing and an actual foreclosure is sort of what I do for a living, which Jane helps out with, the stuff we do all the time for free for people. What happens is you get a foreclosure filed on your house, and then you have to deal with it. Our batting average is pretty good. About 80% of the people we talk to, we are able to save the house, keep them in the house, and stop the foreclosure. We're pretty good at it.
Yeah.
I think that's 10 times, the national average if you're doing this by yourself. Last time I saw a report on this, if you're trying to protect yourself from foreclosure and you could do it by yourself, you got about an 8% chance of success. Whereas our ratios are closer to 80%. They don't go any higher, but they don't go any lower either. They've been there for many, many years. So about 80% of the time. So 8 in every 10 people who call us up and need help, we're able to help them keep them in the house. The other 2, maybe they don't have the income, maybe they're just too far gone. It depends on the situation. But the bottom line here is, and this is why I want to talk to you guys about this this week and why I asked Jane to come in and help us out, is that foreclosures are spiking, and it's going to get worse in 2026. And there are a couple of reasons for that. One is people can't make their mortgage payments. That's the chief reason.
Yeah.
That's what fires it all up. But the bigger reason for all of this is because banks know the same thing that I'm telling you guys. Prices are falling. If you have a house to sell, do it now. Don't wait a year. I mean, if your lifestyle says you have to wait a year because you're waiting for something, that's fine. But just be aware your house will typically be worth less a year from now than it is right now. And it's worth less now than it was a year ago. That's just the reality. So foreclosures are up 20%. Foreclosure filings are up 20%. That's a scary enough number. But the really big number, the really scary number, is the actual foreclosures that are taking place. The foreclosures where the bank is taking back the house, that number is up 40% from last year.
Yeah.
Banks are taking back 40% more homes this year than they did in last year. That is a staggering number in this industry. That is a staggering number in this economy. So yeah, number of filings up 20%, but number of actual foreclosures up 40%. And I can tell you from personal experience, the banks are harder to deal with now than they were even 90 days ago. Certainly a lot harder to deal with than they were 6 months ago. We were talking about this morning. The amount of forbearances and deferments are still out there, but they're much, much harder to get now. If you have a house and you have a substantial amount of equity, but not so much that it's going to guarantee that the bank will make money on it, they're going to want to foreclose now. If you're in that pocket where you've got somewhere between 5 to 10% equity or less, the bank's going to, and you get no foreclosure, the bank's not going to want to deal with you. They're going to want to liquidate you because although they make more money by keeping the loan in play, they're worried that if you have that little equity now, it's only going to get worse over time, and so they want to get their investment out if they have an opportunity to do it now. So
yeah.
It is a bit of a mess. So I tell you what, before we go to break, we got some questions here. These are a combination of things from people who sent me emails, sent us emails. I say us because they want to talk to you, but they don't have your email address because you're doing other things and you're a professional, so they bring them to me and then I bring them to you.
I would never have time to do anything else.
Yes, thank you. So I do take up a lot of bandwidth, don't I suppose. I like to think I'm worth it.
You are.
Well, as long as you think so. I've had her fooled for 30 some odd years. It's fantastic. Don't tell me I'm not a great salesperson. Anyway, so yes, we got a series of questions here. Some are from listeners, some are from other friends of ours, some are from industry folks, and some we just thought we'd throw in there for you guys because you should know the answers to these. So let's start here. This is the first big one I get from everybody all the time, and I'm constantly shocked that people don't know this, but then I do this, we do this all day, every day, and have for 3 decades, more than 3 decades. Oh gosh, almost 4 now. Jeez, it's been a while. Mm-hmm. I'm not that old. We started when we were very young. I'm not that old. Just keep that in mind. Anyway, right. So that's my favorite question. This is my first question I'll ask you, Jane. If you're ready? Ready?
Sure.
Okay. How long does a foreclosure take? What is the timeline?
Well, it varies a lot from beginning to end, of course, but the technical amount of time is a minimum of 111 days because there's a 90-day notice that has to season. A bank, once you're behind, can file a notice of default, meaning that you are officially behind in your mortgage. It doesn't happen the first month. I don't think I've ever seen that. Usually it's a couple of months, but it depends on the bank's protocol. But these days, as we just discussed, the banks are accelerating their process quite a bit, so they aren't going to wait too long. But then once they file the notice of default, it's recorded with the county recorder's office so that it's a publicly available document. And they have to then wait 90 days at a minimum, and then they can file and record a notice of sale, which again is minimum of 21 days. They can set it farther out, but that's beginning to end. If nothing interrupts it, that's where the 111 days comes from as far as the process from the initial legal notice of default to a potential sale of the property.
Well, just to fill in a blank for you guys who are listening, if you're considering, if you just stop making payments, or you're about to stop making payments because you can't afford it, usually a bank's going to wait about 4 months before they come after you with a notice of default. Some loans actually require you to be 4 months behind before they can hit you with a notice of default. Depends on the loan. But anyway, you usually have 4 months of not making payments, and then as month number 5 starts, that's typically when they're going to file the notice of default. And it's just they send you 10 copies of it in the mail, and it's terrifying. I used to refer to it as the lawsuit because the bank is telling the court, telling the world that they intend to take your house. They're suing you to take your house. But I was corrected. It is not actually a lawsuit.
There is one thing, too, I want to point out. But the banks like to, or some of them like to send out something that is not part of this process called a notice of intent to accelerate,
yeah.
Which is very scary, and it is intended to be that. It's intended for them not to have to start the process, but to scare you into getting current with payments or selling the house or whatever. It is simply a notice of what they intend to do in the future, so it doesn't legally mean anything.
Well, it has. We talk about this all the time. It has no legal weight. It has no actual weight except to scare you and put you on notice that the bank is coming after you.
Yeah.
And that in and of itself is scary enough.
And it shouldn't be ignored. I don't mean to imply, of course, that.
You just don't have to freak out about it. Just go get
Correct.
competent help. We'll get
it means something different. You just need to know what it means.
The one you want to worry about is what's called notice of default. We call them NODs, notice of default, NOD. And it says right across, it's a very official looking form. You can't miss it. They'll send you 15 copies of it, 20 copies of it by certified mail. And it's a big deal. That starts the clock ticking. And at the end of 90 days, on the 91st day or thereafter, they can then file a notice of sale, which that has to go another 20 days. On the 21st day or thereafter, they can then file the actual sale. So you got, if the bank fast tracks it and gets after you, you've got 111 days from the filing of the notice of default. So that's kind of your time frame. And most of the clients that we have come in kind of in that time frame. I wish you guys would come in sooner before the notice of default gets filed because we have more options. But they'll typically come in after the NOD has been filed, hopefully before the NOS, although you can still help even if an NOS has been filed. And that's kind of how things started. That's kind of the timeline. So I wanted to get that kind of down for you guys. So remember that. So it's 120, typically, can vary a bit on this part. So first about 120 days when you stop paying. Then it's going to be 90 days after they file the notice of default. And then 21 days or thereafter after they file the notice of sale. So that's kind of your time frame. 4 months, 3 months, 21 days. Those are your time frames. And we're not going to have a quiz later, so if you have any questions, you give me a call. You can always call me at 661-714-1400. That's my personal cell phone number. I give it out all the time, which my wife loves it when my phone goes off at 2 o'clock in the morning.
I do not.
Yeah, we're kind of used to it at this point. Oh, you forgot to put it on? Yeah, I usually get hit in the head with a pillow because I forgot to put it on silent. But anyway, if you need to call me at 2 in the morning, you can call me at 2 in the morning. I'll be happy to answer. I'll do my best to help you out. Just keep in mind the quality of the advice I'm giving you at 2 o'clock in the morning is in direct proportion to the amount of sleep I'm losing. When I was 18, 19 years old, I could do this easily. I'm 54 now. It's a little bit harder. So sleep has become more precious. But if you have a problem, give me a call. If I don't answer, send me a text. Again, 661-714-1400. Actually, if you have any questions right now you'd like us to get into over the air, we've got a bunch of them. If you have any you want us to add, anyone listening, cell phone number is 661-714-1400. Text me your question. We'll get it answered for you. We'll do it here live on the air. 661-714-1400. So those are the timelines. I wanted you guys to get squared away with that. I tell you what, let's go to break. When we come back, we're going to get really into this. We've got a long list of questions here. A lot of people are sending questions. Some of them we had to take out because I'm not telling you guys personal stuff about us, but any more than I already do. But these are all on task. I didn't even show you a lot of those. These are all on task, and I don't know what a lot of these questions are. I'm seeing for the first time this morning, some of them. So let's see what we get. If you have one you want to ask over the air, just send me a text. We'll ask. 661-714-1400. You're listening to The Real Estate Fix. I'm your host, Rich Szerman. Special guest, Jane Szerman, is in here today. She's the attorney. I'm the realtor. That KHTS AM 1220, FM 98.1, your hometown station. Hey everybody, thank you for coming back after the break. Thank you for listening to the show. You're listening to The Real Estate Fix. I'm your host, Rich Szerman, on KHTS, FM 98.1, AM 1220, your hometown station. We were talking about foreclosures and foreclosure defense because we have an attorney in today. My lovely wife, Jane Szerman, has agreed to join us today as my special guest to talk about foreclosure defense stuff. Jane is a real estate attorney with, well, let's just say lots of years of experience.
Yeah, we don't need to count how
Yeah,
many.
you can measure the experience in decades. You know, it's been a lot. And she knows what she's doing. And I'm biased, of course, because I'm married to her, but she's fantastic at this. And, well, her track record kind of speaks for itself. So let's get into some of these questions that people have been nice enough to send us. So let's see. This is one I get a lot. I've missed a mortgage payment. Should I start looking for a new place to live? No. We went over the time frames before the break, but go ahead.
Yeah, definitely. There are kind of two camps on people. There are the ones that freak out initially. They get a notice of intent to accelerate, or they're a few months behind, and they just decide it's all over, and I don't have any options. I'm just going to lose my house. And that's definitely not the case. You definitely have options. And I will say the one thing is the sooner you talk to a professional, the better. So they definitely can't evict you just because you've missed a payment or two. But you want to start looking at a resolution to the problem as soon as possible, because that just makes it easier. It's easier the sooner you start. It gets harder and harder as time goes by.
Yeah, I can tell you 100%. I can tell you from a practical point of view, people wind up in one of four stages. I've stopped making my mortgage payment, and they haven't filed an NOD. That's the easiest to deal with. An NOD has been filed, but it's fairly new. You lose a few options there, but not many. Still fine. My NOD is 5 days away from being fully seasoned, and it's going to be an NOS shortly. Those are much harder because you have a lot fewer options then. Or somebody who's actually got a notice of sale already filed and are staring down the barrel of a foreclosure. You definitely have a lot fewer options when a notice of sale has been filed. But you still have some.
Yeah.
All you need is one good one to solve the problem, and every problem is different. But all you need is one good one, and you still have some, even under those circumstances. We've had people where 2-3 days before the sale date actually was going to take place, we were able to get the house out of we're going to talk about that a little bit today.
Yeah, I was going to say AB 2424.
Fantastic.
There are some options depending on what you want to have happen.
But do you want to talk about AB 2424 now, as long as we stumbled into this part?
Well, you've gone over it the most,
Okay.
so you've dealt with it.
For those of you listening, there's a new law that passed in April of this year called, we refer to it as AB, which stands for Assembly Bill, so it's not actually that, but it's AB 2424, and it manifests in a series of civil codes, which I won't bore you with, but I have them if you need them. But what it basically says is, or not basically, what it does says is, if you have a house that is in foreclosure, if you give the trustee, not the bank foreclosing, the trustee, the guys who are handling the foreclosure, although you do both, if you can give the trustee a valid listing contract, you put your house on the market for sale with a valid California broker, then they have to, and this is the law, and thank you, Pilar Schiavo. She's the one who put this together. Our own Assemblywoman, Pilar Schiavo, did a great job with this. I've been
Very
over
true.
forever for this.
Yeah.
If you put your house on the market, and you have to do it 5 business days, so figure 7 days, and ahead of the actual sale date, they have no choice, they must postpone another 45 days. And having 45 days added to what is a 111-day process is gold. I mean, it's amazing. So then we've had several of these in the office already where we've used AB 2424 to buy them another 45 days. And in that 45 days, we found resolutions with the bank, so they're able to keep the house. Now, it's really designed for you to sell the house. We're kind of fudging it a little to use it to still save houses, but we do.
Yeah, I don't think people should be doing this just to buy themselves an extra 45 days in the house. That's not helpful. It doesn't really get you anywhere in the long run. But sometimes it does give you the amount of time to tap into a retirement account or deal with something with family, or to legitimately list the house and sell it. If you've got any equity, that is your window of opportunity closing for you to sell the house and get what you can out of it.
So if you're curious, you can always just Google AB Alpha Bravo 2424, and you can find out all about the law. Or you can call me, and I'll be happy to tell you about it. If it's a really serious situation, I'll pass you on to Jane, and she can tell you about it. But AB 2424, there are 2 pieces of massive legislation that have passed just this year that are changing the foreclosure landscape in California dramatically. 2 laws that we've needed, I've been begging for, I've been advocating for. We're not quite done because the laws aren't really complete in my view, but these are huge steps in the right direction.
Big help there, yeah.
Yeah, huge help. One is AB 2424, which we just discussed. The other is AB 130, which we'll discuss in a minute. That has to do with the zombie seconds and preventing those, or zombie junior liens, I should say. But anyway, let's get into another question. Okay, so the answer to the question is, if you just missed a mortgage payment, get involved as soon as you can. Get yourself some help as soon as you can. No, you don't have to move because you missed a mortgage payment. As we talked about before the break, you probably got about 4 months worth of missing mortgage payments before they file a notice of default. Then you got about 3 months after they file the notice of default. Then you got about just a little less than a month after that before they foreclose. So you got yourself a little short of 8 months when you start missing payments. That's, give you some time. And it should give you plenty of time to get these things sorted out. If you give us a call, we'll help you. 661-714-1400. Okay, next question. If I ignore the bank's calls and don't sign for any mail, they can't foreclose. In other words, like you're dodging you think you're dodging a proof of service or something.
Well, I mean, that does sound a little silly, but I have gotten versions of that for sure where, people are convinced because they saw a YouTube video or a TikTok about something that if I don't receive notice in a certain way or, something, they've just convinced themselves because they want to, that's, they're just avoiding any legal action that way. That doesn't work that way.
Well, I'm not going to use the name of the client, but you'll know who I'm talking about. We had a client a couple of years ago who was sneaking into his own house at very, very late at night and just sleeping there and leaving because he thought if they can't find me, they can't foreclose. And he really, honest to God, thought they can find the house, man. They know where the house is. They will serve notice at the house, on the house, and they can absolutely still foreclose. They don't need your permission.
Yeah, that they don't need to serve you personally for. Yeah. That's the difference. Now, when you get to something called an unlawful detainer, if somebody is trying to evict you, there is some personal service that's different. Yeah. Right. But for this, they don't need to get a hold of you. They just need to say they got a hold of you, which they always will. Yeah. And they will proceed with or without your cooperation.
Yeah. So sneaking into your house at night to try to avoid service is not any way to live a life, and it's not going to help you at all, which is the other part. So, that's not the way. Let's talk about this a little bit. Everybody has this idea, especially when they talk to a real estate attorney, that there's going to be some aha that they find in the file. Like my favorite is they don't have the original copy of the original note. They don't have the original note.
Those were going around for a while. They don't have the original note. MERS was used to transfer the loan from one lender to another. That is not true. None of those will prevent the lender from foreclosing on the property.
There are very few. It happens rarely, but there are every so often. There's like, aha! Like we had one I talked about a lot where they were missing 14 years out of 17 years worth of the accounting. Yeah. Now, that doesn't invalidate the mortgage debt, but it puts you in a pretty good negotiating position.
It does make things more complicated for the bank. Now, but in that case, because a typical foreclosure is outside the court process, nobody else is looking at this. So in that case, you would need the homeowner or a representative of the homeowner, a realtor or an attorney, to fight for the homeowner with the bank. That doesn't just happen automatically.
Yeah, that's what we do.
You need to be able to assert your rights. So first you need to know them, and then you need to have a good representative.
Yeah, you're also typically better off. I mean, I have a couple of clients who are very savvy and who are terrific. A couple of them who are attorneys. I actually represented many attorneys over the years. And you're usually not in the best position to defend yourself because of these things. You're usually better off. Whoever the advocate is, you're usually better off with the advocate as long as they know what they're talking about. But never forget, your advocate works for you. You don't work for them. And they have to understand that as well. You're having an advocate for you. But it usually works better because you're just, when I advocate for people, even if they're really, very savvy about these things, even if they're attorneys, even if they're real estate attorneys in a lot of cases.
Absolutely true.
You're still better off having somebody else do it because, as I tell clients all the time, I have an edge in fixing your problem because I'm not you. So the bank can't intimidate me. They can't scare me. It's not my house we're talking about. I'm somewhat, not entirely, probably not as much as I should be, but I'm somewhat emotionally divorced from the process. So they can't use a lot of the scare tactics and stuff that banks typically use.
Yeah.
When they do that, they just make me angry. But I need some of my best work that way. But so let's move on to another question. Okay, so I'm behind on my mortgage payments, and realtors, sheriffs came to my door. Is it too late for me to do anything? Well, as we just touched on.
Yeah, I guess the first thing I would say is I have heard a number of situations where that happens, and I've heard it with a sheriff, I've heard it with a realtor, and I've heard it with somebody coming to the house saying that they're the new owner of the property. And there's an example in every one of these where that was just a flat out lie.
Oh, yeah.
They were absolutely not any of those things, and they were simply trying to take advantage. Now, maybe it's getting the person to move out so that they can commit fraud by renting the house. Maybe it's, something else. It's hard to know. People get very creative with their fraud these days, but do not assume that somebody showing up at your door is legitimate. I mean, that's just something unfortunately, the reality we live in, you need to follow up, get business cards, get information to call and confirm, and then talk to your own professional who will give you advice on where things actually stand, because those people won't necessarily be honest with you, and you should never trust what they're saying, whether it's the bank or a realtor or anybody, if they're not willing to put it in writing. That's my general
Yeah.
rule, because I've heard all sorts of wrong information given, and people rely on that very much to their detriment.
Well, I was just going to say that this is not a verbal business. Real estate is not anyway. Foreclosures certainly aren't. Foreclosure defense
No.
certainly aren't. Everything that you should get should be in writing. If somebody shows up at your door, you politely take their card, take it, say, great, send it to me in writing.
Yeah.
You send me a letter. I'll be happy to read it. Can you come to my house? No. I mean, can I talk to you about this anymore? No.
Yeah.
I'll take your information.
don't have
You're
to
welcome
talk
to
to
send me
them.
a letter, and that's it. And if you're already ahead of the game, here's my attorney's card. Go talk to her. Go talk to him. So yeah. All right, let's move on to another question. I heard if my property was transferred with something called MERS, MERS, the bank can't foreclose. MERS stands for, just to give you guys help out, MERS stands for Mortgage Electronic Registration System. And to give you really just a brief primer, what happened is the banks decided that the various assessor's office in the beginning of this century here, the early aughts, was not working quick enough. Actually, it might have been late 1990s. But anyway, they created this system themselves to basically sidestep the assessor's office so they could move quicker, and then MERS would catch you up with the assessor's office because the assessor's office was taking too long. And while I understand the assessor's office certainly takes too long, you're not allowed to just create your own, government system alongside the government. You don't get to do that.
Yeah.
So the MERS system has essentially been shut down at this point.
It didn't invalidate the transfers, though.
Exactly. More to the point.
Yeah. At the
So
end of the
yeah,
day.
so as we said, there are very few of these ahas where my house, I see it says MERS on here, so they never had that. Da, da, da. Before you get yourself down that rabbit hole, let me just help you out. It doesn't invalidate the mortgage. It just does. There are things that do. That's not one of them.
Yeah.
Let's do another one. There was this problem, whatever that problem may be, with the loan foreclosure, so they can't kick me out of the house, right? There was some sort of defect in the filing or something like that. Again, everyone's looking for this aha. They don't
I know.
exist.
Well, gosh, I mean, you and I have both had these. I've heard you on the phone with people, and I know I've had it, where people want to argue about the lender, the mortgage broker, lied to me when I was getting the mortgage, and they told me the interest rate was different, or they said I could refinance it in 6 months and get out of this balloon payment. Whatever it was, they're fixated on something that happened previously.
Yeah.
And sure that then the foreclosure can't happen, or even worse, when a foreclosure has already happened. And I think people need to be aware of focusing on the foreclosure itself, that these incidents that happened previously are in the short term. You can't worry about that. You have to address the foreclosure. That is a separate matter. Nobody's going to get into the earlier actions of anybody, and no judge is going to hear the case, so nobody's going to listen to whether or not they lied to you. So you have to focus on that first.
Let me give you another one just brought to mind. I hear all the time. If a client files a lawsuit, they are automatically protected from foreclosure.
No.
I hear that a lot. Well, can your wife just file a lawsuit for me? That'll stop the foreclosure?
No.
No, because, and you can answer this, of course, better than I can, but you file the lawsuit, and the judge doesn't go, oh, okay, file the lawsuit. Nobody can foreclose now. You have to get a TRO, right?
Yeah, I mean, because that's the reality. You would have to file a lawsuit first, and then go get a temporary restraining order, which in turn, in a few weeks, hopefully would turn into a permanent injunction to prevent them from foreclosing. And while I've tried that a few times in my career when I was a little more young and had extra energy and time to try it, it absolutely goes nowhere. Except for the most extreme circumstances, which I have yet to run across. No judge is going to be part of stopping it because it is a non-judicial foreclosure. If it's a judicial foreclosure, that's different, and you go through court and a judge hears it, and there are motions that you can bring there. But non-judicial foreclosure through a trustee sale, as is most of what we're talking about here, does not involve a court or a judge, and they are not going to get involved, or at least don't plan on it.
Well, you can follow up on the lawsuit stuff, but it's not. If you file it too late, that's not going to save your house most of the time.
Exactly.
The file a lawsuit, just throw it up on the wall, hope it sticks long enough to save my house is just not a strategy that works. It just isn't.
Yeah.
It's just an unfortunate thing. So, it doesn't work. The lawsuit has to be accompanied with a restraining order, and most judges are not going to give you a restraining order.
Yeah, they're not going to see that as their job to get involved with that. Now, the one exception, legally speaking, and that's a little, another question is bankruptcy filing. Though that is something that
don't get ahead of me.
Potentially could help.
Don't get ahead of me. That's the next question. All right, go ahead.
Well, I don't do bankruptcy, so you would need to talk to a bankruptcy attorney. That's the first thing I'll tell you.
We have several.
You absolutely would need to talk to a bankruptcy attorney, but a bankruptcy can help. Depends on whether, what your circumstances are and whether you can file it. But a bankruptcy, when you file a bankruptcy, it comes with something called an automatic stay, which means basically nobody can do anything to you legally or any circumstances. Everything is sort of frozen. And that includes non-judicial foreclosure. So the trustee is prevented from selling it. So that does give you a stay. And then It's a separate matter. Unfortunately, that's not a long-term thing, though. That only lasts for so long because a typical lender will go into court and get what's called a relief from stay, which allows them to sell it. Which, if it's a typical house with a mortgage that's over encumbered, and there's no reason for that stay to stay in place. So the judge will typically lift it, and the bank will proceed with a foreclosure.
Yeah, it depends on the case, of course, and it also depends a lot on the caliber of your bankruptcy attorney, as we've seen.
That as well.
I get a lot of bankruptcy attorneys who solicit me for business all the time, want me to send them clients. I know you do as well. And there are a couple that we use all the time that we've used for a long, long time who are quite good. Those of you who are friends of the show know we refer to Lou Esmond a lot. He's a personal friend as well. He also knows a ton about bankruptcy, and his career can also be measured in decades. He's been doing it for a very, very long time, and he's very, very good at it. And there are one or two others we'll refer to on occasion as well, but it all just depends on your situation. I tell you what, we'll do one more question, we'll go to break. What is the difference between a short sale and a deed in lieu of foreclosure?
Well, a short sale, briefly, is that you are selling the property to a buyer for less than you owe to the bank. And obviously, the bank needs to give their approval.
Yeah.
Now, maybe not just the bank, maybe it's taxes or judgments or whatever, but a short sale is where you sell the property to a third party for something less than you owe on it. Mm-hmm. Whereas a deed in lieu is you give the house to the bank. You literally sign the house over to the bank. That's usually a terrible idea. There's liability with that. I've seen homeowners do that, and then the bank never records it. So the homeowner is then liable for everything that happens on the property. They're liable for taxes and for people who get injured on the property, and they take on all of that until the bank does the recording and actually transfers the property. So I never recommend people do that. There's usually a better option.
Yeah, the deed in lieu, just giving back the house, is, at least in California, is a very bad idea. I've yet to see one where that was warranted.
Yeah.
So I tell you, let's go to break, and we'll come back and we'll walk through a little process stuff. We'll talk a little bit more about AB 2424 and AB 130, because I think those are important that people know these things.
So big ones.
We'll talk about those. So let's go to break. We'll hear from some of the advertisers. Please stay through the break, won't you? Hey everybody, thank you for tuning in. You've reached the Real Estate Fix. I'm your host, Rich Szerman. We're into the third segment of the show today. Thank you guys for listening. If you've just tuned in, we've been talking to my lovely wife and special guest, real estate attorney Jane Szerman, about foreclosures and how to deal with foreclosures and how to prevent foreclosures and kind of what it all means. And if anybody has any questions, you have a little bit of time, you feel free to send me a text, 661-714-1400. And this is what I got in, which is pretty interesting. Somebody sent this in over the air, so thank you. I won't use your name on the air, but thank you for the question. Basically, if a foreclosure happens and I have equity, have I lost everything?
Well, short answer is no, but you have lost a lot, which is why we're trying to avoid foreclosure. There is, if there are what's called surplus funds, meaning the house is sold at a trustee's sale for more than is owed on it, the homeowner is entitled to those funds. Initially, the trustee will hold them, and then they're sent to the state. So you can contact the trustee directly, or you can have a representative contact them. But those surplus funds are the owner is entitled to them back. The problem is the value of what the house sold for at the foreclosure sale is typically significantly lower than what it would sell for in the open market, which is why you would ideally want to do a short sale or something. Or a sale. Actually, in this case,
you want to control your own destiny. You don't want to give it to the bank. The other thing that happens all the time with a foreclosure sale is the bank is going to roll up fees like crazy. $40,000, $50,000, $60,000 in fees is not unusual. So if you had $100,000 in equity and they chew up 50 of it in just nonsense fees because they can charge whatever the heck they want, essentially, then you still have $50,000 that's due you, but you got to go get it.
Yeah. Yeah, definitely those fees will rack up very quickly. If you only have $10,000 or $20,000 or $30,000 in equity, you figure before a foreclosure sale, that's going to be gone. It's honestly, if it's really more than that, the fees will still be less, and there will probably be some money left over. But
I've never seen a client get surplus funds after a foreclosure unless they've been represented. I know you've had several over the years you've represented when we got the funds, but I've never seen anybody get surplus funds that were absolutely due them without some sort of representation, usually an attorney going to the bank and saying, hey guys, you got to get the money.
They do make you jump through a lot of hoops. I've got one now where I'm going back for the third time with a copy of an ID because to them, a signature didn't match, and then another copy sent wasn't dark enough or it's too dark. So they will make you jump through hoops for sure, which again is where if a professional can help you out, that makes everything easier.
Yeah. All right, so let's do this from the top. Let's say you're a homeowner and you just stopped making for whatever reason, you just stopped making your mortgage payment, probably because you couldn't afford it, but you just stopped making your mortgage payment. So when does this get really, really serious? When does it get to be a problem? probably about 4 months in, they're going to file the notice of default. Now, if you can get in front of the problem before then and get this started, that would be smart. That would be helpful. You'll have more options at the outset. But if that doesn't happen, then you're going to slide into an NOD, which is the first legal step in a foreclosure, really. They file it, and then you got 90 days inside that NOD, and there's some things we can do inside to lengthen that from time to time, a few tricks we've learned over the years to hopefully get you a little more time. And then if that doesn't work out, then you're going to notice of sale. And then you're in the last 20 to 30 days, it's at least 21, but last 20 to 30 days typically before the bank takes your house.
Yeah, I would definitely say that it's best before that notice of default is filed.
Oh, yeah.
Largely also because at that point, if you've got, say, Rich or a realtor working for you, they've submitted paperwork to the bank with authorization to allow you to talk to them, with financials, and they've started the process. And often when a bank has an open file for a loan modification or for assessment for a forbearance or whatever it is, they're not going to necessarily move forward as quickly with the foreclosure process. So you can stall it sometimes in that way as well.
Well, if you remember, under the great Homeowner Bill of Rights, huge legislation that came to pass in 2008, then it revised again in 2010. What it says is if you are pursuing loss mitigation efforts with a bank, and the bank has a complete file, those are the magic words.
I was going to say,
complete file. That's where whenever we
that's
start
where
a file.
that's where they always say, "Oh, we didn't have a complete file because there was this
that's
other
always the
document
dodge.
we needed."
Well, that's when we have a client in the office. The first thing we want to do, once you gather up all the documents and everything else, we start talking to the bank. Our goal to begin with is to hear them say the magic words, complete file.
Yeah.
Because as long as they have a complete file, they are prohibited from advancing the foreclosure process. That's the key. They cannot advance the foreclosure process. And that doesn't mean they can't tell you no on a Tuesday and go back to foreclosing on a Wednesday.
Yeah.
But at least it buys you some cover.
It does. And also, even more importantly, when you have a realtor doing this, you have a third party to testify if necessary and document the fact that this was submitted, it was received by the bank. So all the more important not to do it yourself and to get other people to help so it can be documented.
It's also harder for a bank to claim they didn't receive a document because you sent it in when we're sending we're supposed to be a third party. Well, we are a third party. We're supposed to be disinterested. We're not. We're very much on the client side. But when we send it in, it's a little bit harder for them to say that, oh, you don't have it? Well, first of all, here, you can have it again right now. Click, click. Here you go. Got it. And here's a copy of the record that I sent it before, because we keep very careful records for obvious reasons. Now, we talked a little bit about AB 2424 before I went to break, but we can circle back around to that. Before, I want to make sure we get into the show today. AB 130, because this is incredibly important. This is huge legislation, a big deal. It only applies to one segment of foreclosures, but it is a massive deal for the people.
Huge change to that one small segment.
Yeah, exactly. You want to tell them what AB 130 is?
Well, it's essentially, you've probably heard Rich talking about zombie mortgages over the years here, where a bank has gone silent for a long time. They've usually bought it for pennies on the dollar from another bank when a homeowner stopped paying on the loan years ago or filed bankruptcy and thought it was discharged. They show up after a long period of dormancy and demand a lot of money, usually with a ton of interest. It's maybe doubled or tripled the original amount. So that's a zombie mortgage. And in the past, they just proceed the same as everybody else. They have the exact same rights. This AB 130 essentially shifted the obligation from the homeowner to the bank. They have to file a certification saying that they have been in contact with the homeowner, that they have followed all of these rules about sending regular communication and sending statements and, responding. And if they don't, that's an illegal activity, I think is how it's defined in the code. And that gives the homeowner rights, even after foreclosure, to file a lawsuit then, and that is one of the few times that could help. I haven't seen that happen yet, because after foreclosure is a tough time to be, trying to claw your way back. Right, that too. So
April.
We'll see how that turns out, but theoretically, any homeowner can go in after foreclosure, buy a second, by junior lien holder who didn't follow these rules. And I believe in the simplest case, the court has to, order that the trustee or the sale be undone.
Yeah, be reversed.
Yeah.
Let me give you an
which is very unusual. It's literally the only circumstance I know of that's
this
like
is
that.
a sea change in the way the law works.
Yeah,
So,
absolutely.
again, excuse me. Well, again, what it means is if you have a junior lien, so it's not a first mortgage, it could be a second, third, whatever, and they have not talked to you about this in more than 3 years. I've got one right now, it's been 17. More than 3 years. If it's more than 3 years, 3 years and a day, and they can't prove that they've talked to you, or the previous bank that they bought the loan from.
Oh yeah, that's I'm sorry, that's a big part of this. It's not just the current one; it's every previous lender and servicer on the loan.
So if at any point they've gone more than 3 years without talking to you, they cannot foreclose. Now there's a whole rigmarole you have to go through. They're going to say, of course we talked to you. Of course that bank that is bankrupt talked. So there's a little more you got to go through this. But if you can demonstrate, and it's not that hard. If you can we've had a lot of success with this. If you can demonstrate that they have not talked to you in 3 years or more during any period during the a loan, it can't be a 1 month, year one, there's got to be consistent 3 years, then they are prohibited from foreclosing, which is huge because that means that it takes away their weapon. It takes away what they would use to cajole people into paying them, so shaking them down is what I would say. They can't do that anymore. Now, the other half of this is then what happens to the debt. Okay, the bank can't foreclose, now what? What should happen is the bank should be much more willing to deal because they can't foreclose. They can't compel you to pay. What they've done instead is just sort of decided that you'll die at some point. You'll want to sell the house, refinance the house, whatever. So we'll just hang back and you'll just pay us because they're going to keep charging you interest.
Yeah.
We'll just pay there. So God bless the state of California. I'm glad they just came into effect July 1st. So it's a fairly new law,
Yeah,
very new
very
law.
new.
It's only 4 months old, 6 months old, 5 months old. But this is huge, and it's going to become bigger over time. So if you have a junior lien that's coming after you that came out of the woodwork, a zombie mortgage, otherwise referred to as a zombie mortgage, they cannot foreclose. There are a list of things now that they have not done. These are deemed illegal acts, and they're prohibited from foreclosing. But we need state of California, we need the second half of this. How do we get rid of the debt? How do we discharge the debt? How do we sort this out? Because it's all well and good they can't foreclose, and that's huge. But you may still have $100,000, $200,000 you owe them, and that's going to continue to go up. And every time you make a payment on your first, what you're doing is making more room in the equity for them in the second to come and get you.
Yeah.
So it's far from a resolved issue, but this is a huge step in the right direction.
Huge
I can't even
step.
begin to tell you how big
Yeah.
a step this is. We've got clients right now who the bank was foreclosing, was going to take the house. We're running out of options quickly. I got to get on the phone and say, nope, sorry, you failed your responsibility. Your previous bank failed responsibility, so you cannot foreclose. You are prohibited from doing so. So that is a huge, huge deal. So anything else you want to touch on, or we're wrapping up the show here?
Just that in theory, there is a method of adjusting that. It's the one circumstance I've ever seen where a judge is empowered in the law to alter the terms of the note. The judge is empowered, should the homeowner file a lawsuit on the junior lien holder, if they were out of touch, a zombie was out a long time, the judge is empowered to do anything they want as far as the principal amount, the interest that's due, all of that. So that is a nice touch. It probably needs to be expanded, though.
But will they? That's the big question.
Yeah, I don't know.
Also, please keep in mind, AB 130 and AB 2424, we just refer to them as that. They're civil code sections that actually are in the law, just because it's easier. But but then there's more to both of those laws. We're just hitting the high points here because these are what we use every day to prevent foreclosures. So if you have a question about a foreclosure, if you have a friend who has a question about a foreclosure and that stuff, please feel free to give me a call. I give up my personal cell phone all the time, 661-714-1400. I also have a website, richsherman.com. Sherman spelled S as in sugar, Z as in zebra, E-R-M-A-N, because it's pronounced Sherman. It's just a Z in it for no apparent reason. I thought it'd be fun to make Jane spend the rest of her life explaining that's pronounced Sherman, even though it's the Z has the sound of an H.
Yeah, that's been fun.
I had to do it for half a lifetime. I figured it'd be fun to rep you in. You're welcome.
Thank you.
So keep that kind of stuff in mind. So there's a lot more to this. If you have a question, give me a call. If you need to talk to Jane, I can transfer you to her as well. 661-714-1400. We're happy to help you out. We do this for free. We've been doing it for a long time. You've been listening to The Fix with Rich on KHTS, FM 98.1, AM 1220, your hometown station. You guys have a good weekend. Be good humans. We'll talk to you next time.